Hello, everyone. Hi there. Okay. Um, so let's go ahead and get started with the pretrial conference. Do want a couple things. One, just to let you know, we have an observer. Rihanna Graham is a recent high school graduate who's getting ready to go off to Howard University. And we think she thinks she wants to go to law school, so we don't want to disabuse her of that notion. So if you guys can show her some fine lawyering, I would appreciate it. So also, next thing is we don't have a court reporter. Just want to make sure everybody's clear on that. My rules do require that you get your own court reporter for a pretrial conference because mine is busy doing criminal. So I just want to make sure we're all on the same page with that. Okay, so this is set down for a pretrial order and a pretrial conference today. And there's been a bit of traffic, including an amended complaint, which I've not had the benefit of reviewing in detail to determine why it was amended. Mr. Mzikewe, can I ask you to educate me about what was the purpose of the amended complaint and what you were seeking to address?
Yeah. Yes, Your Honor. Two things. The first thing is to get clarity, just to give clarity to the court that we have an issue that deals with piercing the corporate veil. So we did it for that purpose, and then we did add a claim that was that was kind of hinted, but not actually pronounced, and that is the fraud and deceit claim.
Okay.
And pretty much it.
Okay, thank you. The other thing I noticed, Mr. Mzikewe, am I pronouncing that right?
Yes.
Okay, excellent. The other thing I noticed is that you had filed a response to the motion to remove the lien.
Yes, Your Honor.
And one of the reasons I've not entered an order yet, but I had already ruled on all of those motions, and my records indicate that on June 20th, y'all were notified that I was, let me make sure I've got it here, that the motion to dismiss the third party complaint was denied. Excuse me, granted, that the motion for default judgment was denied because the third party can't grant default judgment on a complaint that's been dismissed because no summons was ever issued, and that while Brickell's motion to remove the lien may be substantively correct, Mr. Johnson, who was a third party defendant, is no longer a party to the action, and therefore the motion to void and remove the lien is denied because he's not a party to the case. So I wanted to make sure everybody was aware of that ruling because, like I said, my understanding is that it was provided to y'all by email. I understand all of you are very busy, but it was provided on the 20th, and I requested Mr. Mzikewe, because most of, if not all of those rulings went in your favor, that you provide me with a proposed order dealing with all of those motions. Okay, you're muted, Mr. Mzikewe.
Yeah, apologies. I apologize. I got a screaming child in the background. Please bear
I'm
with
so sorry.
me.
The joys of the brave new world in which we live, right?
Right.
I was just commenting on Mr. Pugh's dog in the earlier hearing, and now we've got a baby in the background. So
Right. Yeah, I didn't remember seeing. I didn't remember seeing those orders, but well, I take that back. I did see them. I did see that the court did make that announcement, and I will. Let me just say it like this: I will do the orders.
okay.
Okay.
So with those orders, where does that leave us from your perspective, Mr. Pugh?
Your Honor, so we are aware of, I'm not going to disagree with your ruling on any of the motions for default or dismissing of the third party complaints. We've reviewed our records in depth, and we were never, to our knowledge, notified or served with a copy of the motion to dismiss that was filed on April 25th. I'm not sure if it was some error with the system or something like that, but it is a motion that we would have liked to have had the opportunity to defend. And we were not aware of that motion until last week. I think it was Thursday night that we saw. It was after you sent your email. We started looking around and we found the motion, but or not the email, but the email was sent out by your staff attorney, I believe, granting dismissal of those third-party complaints. So again, we understand why they were dismissed, but yeah, we would have liked to have the opportunity to respond. And we do believe that Craig Johnson is an indispensable party to this case. Now, unfortunately, we got in the case March 18th, I believe, was when we filed our entry of appearance. And the previous counsel had already filed 3 third-party complaints, and we were not aware that no leave was granted or summons was issued. We were kind of working on a skeleton file to begin. So our immediate thought process was, okay, well, let's get those served. And that's what we've been trying to do. So we were not aware of the summons issue. We're sorry that it caused a headache for the court to have to look at, or if it caused, some kind of inconvenience, we apologize for that. We would like, and I understand that it's late in the game for this, but we would like the opportunity, if possible, to file a motion and put forth some argument that Craig Johnson is an indispensable third party, and see what that might look like if that's something that your honor's okay with.
So, I mean, well, actually, I have a question. From a lawyer's perspective, right? So as the judge, when I go into Odyssey, like I can see the entire docket and I can see everything that's ever been filed in this case. As a lawyer, do you have that ability, or are you only able to see what is served upon you or what you file?
We can see, and I'm not as familiar with Odyssey as I am with Peach Court, but I believe
Yeah.
we can go on and see the docket, but we didn't know that there was a reason to check. We just didn't know that there had been any motion filed
Okay.
to dismiss.
And I'm not necessarily saying that's dispositive. It was as much it was as much for my own edification of what lawyers have the ability to see. But you're correct to anticipate that one of the reasons I also asked that question is that when y'all filed your entry of appearance in March, it was, so here's what I have to deal with, right? So the motion itself, when it was filed, carries with it a proper a certificate of service, and it says that it was served on Mr. Yacklin. Although notably, it says it's, a traditional certificate of service with like a physical address. It doesn't necessarily say by e-file or whatever. But my understanding, maybe I'm wrong, there is an obligation when you enter to input yourself as a service contact in the system so that when documents are filed, you're automatically getting copies of them, number one. Number two, I'm when y'all filed your motion to void and remove lien on May the 30th, the motion to dismiss third-party complaint was already in the system and was, could be seen as part of the docket. But all of that is a long way of, I don't necessarily want to punish a party for, new lawyers, but I also don't want to reinvent the wheel or restart everything. One concern I have is, we are at the pretrial order stage. This case is supposed to be going to trial. But I will grant you that Mr. Johnson's role in the case is certainly something that has been known to all the parties all along. It was just whether or not he was properly made an actual litigant to this case or not. Mr. Mzikawe, what are your thoughts on that, sir?
Two things. One of the things that we kind of lightly addressed because in our previous meeting without counsel present was the issue that they were using Peach Court versus Odyssey.
Right.
Okay, and so I think that plays a role in it. I did send copies over there, but I don't know exactly what happened with all that. But beyond that, if at the core of the motion to dismiss is those summons. And those summons is something that has never been, even in a rush to correct, that's something that has never been filed. And so
Right, and let me clarify, Mr. Mzikawe, I'm not suggesting that I intend to revisit my ruling on any of those issues because at the end of the day, leave was never sought, right? And even your motion didn't even raise that issue. I noticed it when I was considering the motion and realized that leave had never been granted. I think, though, given that you are talking about a piercing of the corporate veil, amended complaint, right? Which I agree with you based on the theories that you were pursuing, probably already there in terms of what the parties were preparing for from a discovery perspective. But given that Mr. Johnson has sort of been on the periphery of this case from its outset, I'm wondering what your thoughts are on what seems to be an effort by Mr. Pugh on behalf of Brickell to perfect Mr. Johnson's involvement in the case, either by amending a pleading or by, arguing that he's an indispensable party, something like that. What are your thoughts on that?
I think that that's something they would have had to prove. I think that as far as the contract is concerned itself, going to the contract and going to the way my client did business, it is a boy wonder. It's a boy wonder contractual obligation, and it's an obligation on the naked face of it between Boy Wonder and Brickell. And so, for him to be personally involved in the lawsuit as a party, there has to be an argument made for that.
What has actually been accomplished in this case in terms of discovery, written or otherwise?
There's been a few documents that they provided with respect to some communication, some invoice information, things like that. But what I have not received is American Express documents. I think that's probably the biggest and most relevant thing that plays a part in this.
Okay. Mr. Pugh, I know part of the reason that I'm taking a little bit of a hard line on we didn't know that it was in the docket is because, especially if you're going to tell me that you got a thin file, maybe one of the first places you would go look is what is in the docket. Setting that aside for a moment, what, from your perspective, what has actually been accomplished in it? Granted that we are at the pretrial stage, that you had a scheduling order, that the deadline for dispositive motions, the end of discovery, all of that is long past now. But I get the impression from the docket and from talking to the attorneys that not a whole lot of substantive discovery was actually accomplished in this case. Mr. Pugh, what are your thoughts on that?
Yes, Your Honor. I mean, to this point, most of our efforts have been trying to perfect service on those third-party complaints. We were able to do so on the Cool Runnings and Marlin's General Plumbing fairly easily. We've attempted service on Craig Johnson, I believe 5 times that we have on file. We've been trying all kinds of different properties that are registered under his name, and we've asked Mr. Mzikawe before dismissal of the third-party complaints was entered. We asked him several times to acknowledge service. So most of our efforts have been trying to track down the parties that we think need to be a part of this case. And we came into this with the full expectation that we were going to perfect service, answers were going to be due, and then as a matter of law, discovery was going to be reopened. And that's when we were going to be able to go and gather all the relevant information. So I wish that we had been able to focus more on discovery in this time, but we were for a long time trying to perfect service and make sure we had all the proper parties involved.
Understood. I guess what I'm trying to figure out, and I should preface this by saying I am probably one of the least likely judges to say, oh, well, we need to reopen discovery and let's not set this case for trial. I am definitely somebody of, no, this case has been pending for 1.5 years. It needs to go to trial. But I also don't want to try the case twice, even if it's 2 different versions of it. And what I'm wondering, what I'm flirting with, Mr. Mzikawe, and I want your thoughts, given that you have filed an amended complaint, which while I agree with you that probably those claims were there, they are new claims, particularly the piercing the corporate veil. That if the court were to delay the trial, to reopen discovery for some brief period of time, let the defendants take whatever reasonable steps because there has been an effort to make Mr. Johnson a party. It's just not been procedurally proper. And if the proper procedure were followed to make Mr. Johnson a party, I don't know that the court wouldn't grant such leave, but for the late stage of this case. And so if the court were inclined to consider allowing Mr. Johnson to be made a party properly, and then make some effort to serve, whether it be through a request for an acknowledgement or through publication based on the multiple efforts, et cetera, that would push this case back fairly significantly. In terms of, even me conservatively with publication issues, my guess is this case is going to end up getting pushed back by at least 6 months before it would be back on a trial calendar, assuming that would give time to get service through the longest possible way, which would either be a request for acknowledgement under Rule 4 or publication, and then some brief period of discovery, and then you guys would be right back in front of me again. What are your thoughts on that, Mr. Mzikawe? Do you feel strongly that I should not do that, or can you live with that?
No, in all fairness to all parties, including the court, I think based on what I filed, and I think based on kind of just the character of this case, just how, I'm talking about procedurally, how it's run. I think discovery, to me, is the driving thing that I think maybe be, an avenue for everybody to get what they want. But I think reopening discovery for a limited period, I think that's necessary for all parties.
Mr. Pugh, are you prepared to, in short order, submit a motion for leave to file a third-party amended complaint, or to perfect it in something that would make the effort to serve, to join Mr. Johnson valid, so that, because I'm not prejudging if you're going to argue he's an indispensable party. I'm not saying he is, but I am acknowledging the reality of the case, which is that from a very early stage of the case, there was an effort made to join those 3 individuals, albeit procedurally insufficient effort. What are your thoughts on that, Mr. Pugh?
Yes, Your Honor, we could certainly do that. And if I may further just point out that a lien was filed on Brixwell's property, not in the name of Boy Wonder, but in the name of Craig Jamel Johnson. So I believe that by doing that, he subjected himself to this case. He threw him, even if, we weren't even pleading that we were trying to breach or pierce the corporate veil. He put himself in the middle of the controversy and filed a lien, not in his company's name, who, as Mr. Mzikawe pointed out, was the party to the contract, but in his own name. And
right.
So we would love the opportunity to do that.
Right, which is why I denied the motion to remove the lien, because Mr. Johnson's not a party to the case. Although, the substance of what was argued may end up proving true. I don't know, in terms of the timing and the procedural process that's supposed to be followed for the perfection of a lien. But that's kind of what my thought process here is, that this case is not ready for trial, that if I push it to trial right now, probably what's going to happen is we're going to end up doing this all over again. Either because we have to do it with a second set of defendants, or because somebody's going to voluntarily dismiss and refile, and then we're right back where we started. So here's what I propose. I propose reopening discovery, setting and I'm going to have one of y'all draft a proposed scheduling order, and there will be a deadline by which, and it will be a very short deadline, like the next 20 days, to add any parties. To the extent that anybody is going to add any parties, given what I think I understand about Mr. Johnson's relationship to the plaintiff in the case, if Mr. Johnson wants to join the party as a party plaintiff, or if the defendants want to join Mr. Johnson as a third party defendant, that will be the time for y'all to figure those things out and file proper motions to add parties or to assert, to seek leave of court to assert third-party claims. And then there would be a brief period of time. I mean, discovery would be going on between the parties. But presumably Mr. Johnson and or whatever other appropriate defendants would be added and then would have the benefit of that discovery period as well. So here's what I'm gonna do. Let me look at a calendar really quick. Okay. So if you guys will send me a proposed order that extends discovery through December the 20th. And sets a deadline of July 26th to add parties or seek leave to add parties. Now, my preference is if we're just talking about Mr. Johnson, I would expect that whatever we're doing, that the proper motions would be filed sooner rather than later so that Mr. Johnson, if he's going to be made a party, could be made a party sooner rather than later. And then the parties could conduct discovery and let me know. What the status of the case is. My intention would be to set it for trial in January. And that would be the plan, right? So what I would want is for the two of you to submit a proposed order that includes a proposed amended scheduling order. I'm looking, it looks like the most current scheduling order is the one that was entered October the 23rd of 2023. And so this would be the second, or would this be the first amended scheduling order? Let's see. Yeah, this would be the first amended scheduling order. And it basically just use the same table that I always use, but put in the dates that we've discussed. Y'all can add additional dates if y'all think they're relevant or necessary. But to me, what matters here is a discovery deadline, a trial date, and a deadline by which I normally don't include, a deadline by which to add parties. But in this particular instance, I think it makes sense to make this a hard deadline by which to add parties and or amend the complaint. Since Mr. Mzikewe has already added claims, has filed an amended complaint. Any questions, thoughts, concerns, other issues that we need to address besides that? Mr. Mzikewe?
No, Your Honor.
Mr. Pugh?
No, Your Honor, that's all for us. Thank you.
Okay, so can y'all, today's Monday, y'all can get that to me this week?
Yes,
Okay.
Your Honor.
Okay, so
Yes, Your Honor.
we'll get it on file. Mr. Mzikewe, please do go ahead and get me the order that I asked for on all the other outstanding motions. So we'll sort of start with a clean slate and go from there. Okay? Thank you all. Have a good day.
Thank you, Your Honor. You too.
Thank you.